Welcome to the second day of this wonderful conference on artificial intelligence and law. An apology, this is my first day because I was absent yesterday. The panel's topic is ethical issues. We have three speakers, probably three speakers if the third speaker shows up. One ethical issue, of course, on panels is to keep in time. And one thing that Germans like myself are famous for is being strict on keeping time. So I will confine mostly my task to making sure that speakers remain on time because they will be brilliant anyway, but then ideally we have some chance to discuss afterwards. We will start with the first speaker. This is Jean LASSÈGUE from the Centre Georg Simmel at the École des Hautes Études et Sciences Sociales in Paris, and I put a timer in front of you, in fact. You'll see what's happening, actually, and I'll give it the floor to you. Thank you very much.
Thank you.
You have, yeah.
So you will tell me. I have 20 minutes, right? Okay. So my name is Jean LASSÈGUE, as Chairman just said. I'm a researcher in Paris. And strangely enough, I'm not a jurist, I'm a philosopher. I started by doing philosophy of science, and especially I worked on the emergence of computer science, especially working on the work of a British mathematician, Alan Turing. And this put me in contact with law. And I wrote several books with a judge on the digitalization of justice. That's why I'm here. And so the title of my talk is a bit provocative, and you appreciate, I'm sure. What becomes of the rule of law in times of weaponization? So first, as a general introduction, I would say that any activity is defined by the means deployed in pursuit of a given end. But when this relation between ends and means becomes opaque, well, things happen. And what happens? Well, these means may be diverted towards different ends, or even turned against the very end they were intended to serve. And this is precisely what happens with weaponization. It's a kind of autoimmune disorder that attacks what is supposed to defend. I'm going to give an example, a very well known, which is the DOGE Department of the United States. You know that this new department, after the election of Donald Trump, was established to promote digital simplification. And it's in fact the merger of two US services. One is called the US Digital Service, and the aim of the service was to streamline digital procedures. And the US DOGE itself, which is a temporary structure, which is supposed to end by the next Independence Day on the 4th of July, and the aim of which is to axe public administration workforce. So, although officially it aimed at accelerating digital simplification, in practice it's an instrument that in fact tries to dismantle the very state and infrastructure that it was meant to reinforce. This is what I mean weaponization. Okay. So there are, of course, many examples of this in many different fields. I'll just mention education, where the use of digital technologies has led to a regression on basic learning skills like reading, writing, and numeracy that you could find, and you know many examples on healthcare, finance, and other areas. So what I mean by weaponization here is that it produces a persistent ambiguity regarding the ends, and it generates an uncertainty, a collective uncertainty and a collective pressure. And I think this has to do with algorithms. So first, the term algorithm refers to any procedure which is decomposable into steps that guarantees the solution to a problem. And it has two features: it's deterministic and it's automatic. But we have to be very aware of the fact that such a procedure doesn't always exist. So there are very well-defined mathematical problems that cannot be solved using an algorithm. So this is something we should keep in mind. Algorithm is, of course, a fantastic procedure, very useful, but it can't be used everywhere. Okay? So there are non-computable processes, and this has been proven in mathematics. It's famous Gödel theorem or Turing theorem. But there are also non-computable procedures in physics and biology, which means that we can ask the question, so if it's the case in mathematics and natural sciences, why not in law? Maybe there are some non-computable procedures in law. Okay, so the hypothesis I want to put forward is that these non-computable processes in law have to do with the prediction, prevention, and prohibition of future behaviors. So the use of algorithms does introduce some kind of structural problems, and this may result in weaponization. So if we go back to daily life, the use of algorithms becomes very problematic when the aim is to control future behaviors, because of course an algorithm is always deterministic, so it imposes some kind of certainty on a very, very uncertain environment. And that's the problem. So yesterday we heard Dr. Aslan, who described various problems like opacity problems with algorithms, amplified biases, and dehumanization. I think all these problems have to do with the use of, in particular, use of algorithms. And why is that? Well, by using statistical methods applied to vast quantities of data concerning past behaviors, we are supposed to detect regularities which serves as norms. And yesterday Brian Klein made a very nice comment on the difference between regularities and norms, as if we could identify the two. But in fact, in the case of future events, that's not the case. We can't identify regularity and norm. So if you think of how we use algorithms in this context, you see that each individual is placed within a group which is presumed to be his group of belonging, and from there, this average behavior is projected back onto the real individual through algorithmic processes which are both performative and deterministic. So, we had a great example yesterday given by Michi and on the recruitment processes and the gender inequality that it brings. I thought of another example, if a person's loan request is rejected, it is because he or she has been categorized as high risk, regardless of his or her particular situation. We know all these examples that we just discussed. So the function given to the algorithm is therefore to match the behavior of a real individual to that of the average individual. And of course, this is very problematic because this difference is supposed through the algorithm to disappear more or less smoothly but it does not. And why is that? Well, it's just because social reality is full of unexpected situations that cannot be predicted at all. Okay? So if it's the case already in physics and biology, there is, a good chance that it's also the case in social. So what does this digitalization of law introduce in terms of legality? So I will make a difference between the rule of law and the law of rule. Okay? So the rule of law, let's say in the case of justice, justice requires, of course, a collective trust in basic instruments of law. First, a specific place, empty at the center, which is the courtroom. Some physical distance and proximity between individual group and groups in conflict. The capacity for mutual speech, given in terms by a recognized authority, namely the judge, most of the time. And, of course, ways of evaluating conflicts given by a series of written text, at least now, and procedures. And, of course, the end is to look for mutual agreement, which is either reached in a final decision, the basic aim being to avoid private liability. So this legal resolution of conflicts requires, so you can't see the end of my presentation, doesn't mean, so it requires a social way of specialization of conflicts. I think this is very important. We are speaking lawyers living in a three-dimensional environment, and this is precisely what what is not the case with digital. So the law of rule, in comparison, is the aim is the conformity of law to the rule. So we're told, for example, that it is the machine rather than human agents that determines whether a bank grants a loan to an individual, whether a student may enroll in a given academic program, or more subtly, which book, film, a holiday destination, or even life partner to recommend. And so this has huge effects, of course, in society, as it shapes collective preferences on a very large scale. Okay? And I will give an example of a new way of making justice online through this algorithm process. I don't know if you know about Clemens. So it's an online dispute resolution platform. The aim of which is of course, to solve conflicts online. And so the problem is how to build juries. Okay, so the jurors are anonymous. So what is the interest? What motivates an individual to act as a juror? Well, the incentive is primarily financial. And why is that? Well, first you have to pay an entry fee, which is at least 500 euros. It's not nothing, I tried myself, so I know what I'm talking about. And it has to be paid in a very specific cryptocurrency, which is called Pinacchio, okay? And which is, of course, the only currency which is accepted by players. So, and jurors may expect to make a profit if their decision coincides with the majority opinion in the case of the case they adjudicate. Of course, they lose money if they diverge from it. So, the juror's participation is driven by the prospects of a financial gain and not, of course, on shares. So that's a new way and very problematic. to doing justice. It was just an example. Okay, so I will reach my conclusion. The paradox of algorithmic governance lies in the fact that although it operates within uncertainty, it leaves no room for deliberation. So, of course, there are pros and cons in using algorithms, because of the deterministic approach to reality algorithms have. But when the future is concerned, of course, well, the future is not written, and in that case, it was come. So to suggest that algorithms alone could determine the future is in fact to renounce collective deliberations under conditions of uncertainty. And this entails to concede that computation alone should govern the public sphere, which I think is not the case. So we are put in a dilemma, and this is my last slide. Either algorithms, the use of algorithms is a decision-making aid, or it's a way to replace judgment. And I think that the answer to this dilemma is not computable, so it needs to be examined on each occasion. So we can use algorithms, of course, but we have to decide collectively where to use them and where. So I think that the use of algorithms has to be controlled from outside and from a political society, and it needs, of course, careful and collective deliberations and monitoring. Okay, I hope I'll time, Mr. Chairman.
Thank you very much. That was very good. I'm sure a lot can and will be said about it, and we'll do that after we've had the presentations. And we'll move on now to Professor Dr. Talgat SARSENBAYEV from Northern University, where he's the director of the School of Law and Public Policy. Thank you very much. And he'll speak on the opportunities and challenges of personal data protection in Kazakhstan.
Good morning, ladies and gentlemen. First of all, it is an honor for me to speak today at this conference and to support Istanbul University in their sincere efforts to raise important questions for academia and the practice. We live in a time when personal data is often regarded as the new oil of the digital world. How we protect this data defines our basic right to privacy and is the level of trust people have in technology. Kazakhstan, like many other countries, has taken important steps to protect personal data. In 2013, we adopted the law on personal data and its protection, which gave a definition of what personal data means, explained people's rights, and set the ground rules for those who collect and use personal information. This law required that personal data could only be collected with a personal consent and for specific purpose. It also stated that people's data must be stored on servers inside Kazakhstan. This helps the country to keep control over where and how citizens' data is stored. Some international experts criticize this rule, that it demonstrates Kazakhstan's strong commitment to protecting its citizen information. Today, digital technology is used in almost every area in life in Kazakhstan, from education and healthcare to business and banking. We are proud of many of our students in the digital sphere, especially to the sector of finance and the banking. Importantly, we are also following global trends. For example, the European Union's GDPR, General Data Protection Regulation, has become a worldwide model for privacy standards, including Kazakhstan. I believe it is useful to adopt successful international practices and they implement them according to a national legislation. Over the past few years, Kazakhstan has significantly upgraded its laws to make data protection more practical, effective, and up-to-date. From 2023, several important reforms have been introduced. First, in 2021, the Ministry of Digital Development became the main body responsible for protecting personal data. It currently monitors compliance to law, reviews complaints, and identifies violations. The second, in July 2020, companies must appoint a person responsible for data protection, similar to the European Regulation on Data Protection Office. Third, in 2021, all organizations in Kazakhstan must report that the data leak or illegal access to personal information. In the beginning, the fines were around $600. It was a small amount of money for fines. That's why the government continued to update its measures for personal data protection. In 2023, new laws were adapted to further develop cybersecurity and to protect personal data even more. Two key rules were introduced here. First, a ban on copying ID documents unless required by law or when digital integration is not possible. The purpose of the ban is to reduce the practice of uncontrolled copying of people's identity documents in banks, notary offices, and other organizations. Since such copies are often stored without proper protection. Second, mandatory notifications to citizens if their personal data is leaked. If there is a gap in protection and your data has become available to criminals, you must find out about it officially and not by accident. So, if your data is stolen, you must now be officially informed. This means that people could take quick action. For example, change passwords, block cards, or contact their banks. Starting from January 2025, new amendments to law increase maximum fines for data protection violations to around $15,000. There is also a new rule that includes the punishment for anyone who uses someone else's digital signature without his or her permission. This steps legal Kazakhstan's stronger legal foundation for data protection. What began a basic legislation in 2013 has now evolved into a much more strong framework, bringing Kazakhstan closer in line with global data protection standards while addressing local issues. However, any good law is best tested in real life. Kazakhstan has faced several cyber incidents that showed weak points in our systems. For example, in June 2025, the media reported a leak involving 60 million citizens' records. In 2024, there were several other cases. A database found of GitHub, a microfinance company exposing the data of 2 million clients, and even a university accidentally publishing medical data of its students. Each of these cases revealed a serious lesson for both companies and the government. Usually, such problems have two causes: technical issues and human mistakes. Sometimes the latent data comes from past incidents that went unnoticed, and later reappeared online. The key lesson is simple. Data protection must be an ongoing process. It requires constant monitoring, security checks, regular updates to how data is shared and stored, an audit of actions of administrators with access to sensitive information, and a revision of rules for data exchange between different departments. Last but not least, appropriate governance, structure, and the mechanism are required. The latest laws and the amendments require organizations to notify not only the government bodies, but also the affected citizens. This builds trust and motivates companies to protect data better. Knowledge, trust, and the capacity building are key factors in developing the right ecosystem. It is also encouraging that public awareness of cybersecurity in Kazakhstan has reached 80% in 2024. This means that citizens are becoming more careful and informed. The government supports citizens with practical instruments. For example, on the government website, the Nomad Guard service lets everyone check if their personal data has ever been leaked. Citizens can also share their ideas or report problems through online government. The service strives to constantly monitor and improve the system. There are also cybersecurity centers that help share information about threats and the protection methods. For example, the State Technical Service and the SARSENBAYEV Cyber Attack Analysis Center. Ladies and gentlemen, I would like to draw your attention that in 2024, Kazakhstan took another important step forward. We officially recognize white hat hackers who legally help find and report vulnerabilities in government system. This is a modern and a positive approach. It shows that we prefer to fix problems, not hit and deal with them later. Another important aspect concerns the biometric data. Fingerprints, facial scans, DNA should have dedicated regulations. For example, collecting biometrics only with informed voluntary consent, having strict storage safeguards, encryption, shorter retention periods, and prohibiting sharing them without explicit authorization. Children's data also deserve special protection and separate regulation. Every incident is both a challenge and an opportunity to grow stronger. In fact, many of the latest legal reforms in Kazakhstan were inspired by these real-life cases. Learning by mistakes may be hard, but it is necessary in a world rapidly evolving in technology. In the future, Kazakhstan may consider creating an independent data protection agency, as many countries have done. This could increase public trust, especially when it comes to assessing how government agencies and the big companies handle personal data. International cooperation is also very important. Through sharing of experience with key global partners and joining international networks like the Global Privacy Assembly, Kazakhstan can continue developing its system and learning from other successes. Only through joint efforts, comprehensive and sustainable change can be implemented. Ladies and gentlemen, the digital world gives us many benefits, faster services, better communication, and a stronger economy. But the key to all of this is trust. Without trust in how our personal data is protected, no technology can truly serve people. Kazakhstan is building this trust step by step through better laws, stronger institutions, and open communication with society. Thank you very much for your attention. Thank you.
Thank you very much. We are, in theory, supposed to have a third speaker, Dr. Valentino CATTELAN.
Hi, can you hear me?
He's online. Oh, I didn't know that. Excellent. Yes.
I am
Wonderful. Awesome.
Thank you. Can you hear me?
Yeah, we can hear you.
Yeah, well, unfortunately, I'm sorry, but I lost my voice days ago. And then, let's say, you will hear me robotic voice, which was unintentional, but I can speak about digitalization. Gives us some sort of embodiment of the topic. I think I should share my screen, but it's not possible. I don't know if the organizers had my PowerPoint presentation. Or I think I talked about the PowerPoint.
Can you not share the screen on the, well, in Turkish here, but on the bottom of your screen?
Yeah, now it's working. Okay. Can you see my slides now?
I can see something. I can't read what it says. It gives your names. I can read something. Yeah.
It's Robo-Shariah. Okay.
Yeah, I can see.
Okay. Okay, well, I must say that, first of all, I'm very happy to give this presentation after what Professor Jean LASSÈGUE said before, because there are actually strong points of contact. I refer as well as speaking about Robo-Shariah to aspects of space, body, justice. I say moving from what we call the rule of law to what we may define the rule of Sharia. So this is basically a presentation which relates to the transmutation, historical transmutation of what is Sharia into social representation and how this can lead to strong ethical issues in relation to robotics and digitalization. So I moved from the attempt to understand something, I would say, quite recent in an emerging field of the financial market, which is Islamic finance. Now, of course, I'm not going to give a full description of what Islamic finance is. Sure, many of you are aware of this segment of the market, which works according to parameters of Sharia compliance. The new product available in the market of Islamic finance is what has been described as Sharia compliant robo-advisors or halal robo-advisors or Islamic robo-advisors. If you Google all these keywords, you have a lot of websites about that. It's actually a recent invention, and during this talk, I will try to show how much speaking simply about Sharia compliant robo-advisors in my mind is like looking at the symptoms of some sort of disease without thinking carefully about what kind of illness is there, and the illness is what I describe as Robo-Shariah, which is something quite different from Sharia compliant robo-advisors. So just to give you the background of this research, robo-advisors are what? They are basically a digital platform of Islamic wealth management, where some sort of robotic advice is given according to parameters of Sharia compliance, ethical investments, and with automatic diversification of the portfolio. So they represent, I would say, the final step of what is usually described as Islamic fintech. We have the growth of the digitalization of financial transactions in the transnational market. Islamic finance is a segment of the transnational market, so it basically replicates what is fintech in the conventional market. If you make your own research through Google and ask for examples of halal advisors, you may find easily that the first one was Wahid, which was created around 10 years ago in New York, followed by this other platform called Algebra, the first robo-advisor in Asia. So the market is growing, and in the attempt to understand how many robo-advisors we have today, I was not able to find the information, so I asked ChatGPT, and as you can see from the slide, not even ChatGPT could give some sort of answer to this, which explains somehow why this field is still problematic. It's internet growth and is still deeply under-regulated or totally unregulated. Now, as I said some minutes ago, this presentation is not really about the regulation or problems related to the description of Sharia compliant robo-advisors, but it's actually more linked to ethical aspects. And this is, I would say, a research stream on which I have worked in the last 5 years. So, I mean, there is a continuity in my research about this. Moving from the parameters of Sharia compliance in the Islamic finance into the impact of robotization in relation to what is Sharia and how Muslim believers live according to Sharia. Now, in order to look and to understand better which are the ethical issues related to robotization in Islamic finance, I suggested a methodology that combines legal studies and legal sociology in relation to the assumption that law itself is a language and a change of technology in the normative space gives rise to a change in normativity as well. So, moving to the first aspect of the methodology, I just want to focus on an important quote by Marshall McLuhan, a very famous sociologist of the 80s. And this quote says, "The medium is the message." Now, it's not that easy to understand deeply what this means. But let's say, in summary, that the fundamental idea by saying the medium is the message is that each medium, each technology defines a unique type of environment in relation to which we human beings shape communications, but not only communications, also our behavior, our culture, and our society. This has become clear in relation to the digitalization of our society. We act today much differently than 20 years ago in relation to smartphone, in relation to how we approach social reality, and now the impact of artificial intelligence clearly is changing again the message in relation to this new medium. So human interactions by themselves are always affected and amplified by the language that we use, and the type of language depends on the type of technology that is employed. So new technologies, this is a a point made clear by Marshall McLuhan in different books, and the Gutenberg Galaxy, the Global Village, understanding media as the extensions of man. This technology is not simply something that we use to communicate, but it reinvents our society. And the medium changes the message and the space for this message. Now, to make this point a bit more approachable, I'm not in Istanbul, so I thought about how to be there, at least visually. Now, if you look at this dome, this is the dome of Hagia Sophia, but it's actually very similar to style to what you find in the Blue Mosque in Istanbul. This type of space is a verbal space. It's a verbal space because it immediately transmits the idea that the Quran descended to the prophets is there to give light to the life of the believers. And the oral transmission of the message of God is always there. If there is not the writing in Arabic, in Islamic mosques, we have patterns of repetitions. Here, an example is for the magnificent, this big tile, which is the idea. The idea is that the man is asked to repeat the life of the prophet. So it's not by chance that these patterns are over-repeated, and this style doesn't exist in Christian architecture. It's quite rare. If you enter a Christian church, you find the body of saints, you find statues, and not by chance all these are actually absent in the Islamic traditional architecture. So the space, this is an example of how the medium makes the message. The space of an Islamic mosque is expression of the verbal message of the Quran. Now, if Sharia by itself is a verbal message, clearly the big question is how does something called the Sharia-compliant robo-advisor change these parameters? And this is changed in relation to the robotization in terms of what a robot is. A robot implies some sort of servitude, and this is what is actually leading to the use of Sharia in the digital world. Now, moving to the side of legal sociology, this implies clearly an impact on the process of what is halalization, the process of transforming the products into halal products, which is exactly what Sharia compliance is doing in the Islamic market. And the next step of this process of halalization is made through the robotization of Sharia. In brief, as I already said, what is the implication of halalization in the market is that the moral regulation of conventional finance is actually entering the Islamic finance as well through a process of certification, which is already there in Islamic finance. The next step is to make this certification somehow through robots, so without even the intervention of a human person. And at that point, the robotization of Sharia compliance, in my opinion, becomes itself a robotization of Sharia. Now, the terminology here is essential in relation to understand deeply what is the impact of the medium as a message. If we assume that Sharia is robotized, then we imply that there is a certitude of Sharia. So Sharia itself becomes some sort of an aspect of a robot working not really in relation to an ethical dimension of a verbal message, an ethical dimension of the market. And in this sense, the robotization of Sharia, if paradoxically defines itself as a way to follow Sharia, in fact, the final effect is the opposite. We move away from Sharia to apply the language of the conventional market through the robotization of the market itself. So it is this new technology changing the language of Sharia in relation to the conventional market, which in the end is able and is actually already changing the message of Sharia itself. Now, all this may be looked also through some sort of an historical approach, and this is part of the research stream that I mentioned at the beginning of my talk. Clearly, this is not the first moment in which the message of Sharia has changed in Muslim societies. In fact, historically speaking, we have already had different media shaping in different ways God's message, shaping Sharia differently in the lives of Muslim societies. Now, what I have done in my research is to try to summarize these historical stages in the variations, the transmutation of the message of Sharia in relation to the technology that has been used to express this message. Now, if you think of the historical evolution of the Muslim societies, if during the medieval time Sharia was embodied directly through verbal transmission of people, through recitation of the Quran, so I use here the label bio-Sharia, its sociology has already changed radically when it has been transformed into Islamic law in Muslim modern states. So we had already the passage from bio-Sharia into state Sharia. Islamic law itself, and there are a lot of comparative legal studies on the point, also from the perspective of the coloniality, is actually a reinvention of Sharia according to the modern state of the Western legal tradition. Now, I have already argued in some articles that Islamic finance changes what is state Sharia into title Sharia. Sharia compliance certification, which is the process used in the Islamic financial market, is something completely different from Islamic law in Muslim states. It's different because it involves aspects of standardization, transnationalization, globalization, which again change the technology applied and then the message itself. The final step, so the next radical change in relation to technology of the message of Sharia is what I have used for the title of this presentation in terms of Robo-Shariah. Robo-Shariah, in my mind, is quite relevant from an ethical dimension because it makes Sharia somehow subservient. So there is a servitude of Sharia with technology, which is not even actually controlled anymore by any human being. So if we look at Sharia in terms of the embodiment of faith, of ethics by Muslim believers, clearly this creates a huge issue, both in terms of epistemology, sociology, legal philosophy, but also theology itself. Now, to conclude my talk, while making some research on this topic, as you have understood, I also care about the visual representation of law. And I found in one of the websites of these Sharia compliant advertisers the picture that you can see on the left that is actually mimicking what you will find in the Sistina Chapel in Rome, in Vatican, in the famous creation of Adam by Michelangelo. Now, this change of aesthetics, I would say, this change of representation of Sharia, which moves far away from that pattern of repetition that we find in traditional Islamic architecture, is revealing to me of this deep epistemological change. Of course, you may even argue that this image may represent some sort of Christianization of Sharia. Now, this concept, I know it's very problematic, but if we start depicting Sharia according to Christian visual images, it represents a problem today as a legal scholar who is interested in the law as a medium to define the normativity of people. There are already studies on capitalism as an expression of the theology of Christianity, so I mean, this is not the topic of this talk, but for sure we are moving away, far away from the original message, Sharia, in relation to the robotization and robots. And I think that this is something that really requires more investigation and more attention, comparative legal studies as well.
Thank you very much. Thank you all three speakers for indeed keeping in time, but also making sure that we had a very coherent panel, I would say, if I identify especially the parallel between the first and the third presentation. The first, if we want the question to what extent AI, if we view it as a technique, and if we realize that the law has always relied on some kind of technique, and let's say, rightly pointed out that the algorithm is not an AI invention, it is a way of programming that is also familiar from the law to some extent. And we saw in Dr. CATTELAN's presentation a kind of continuity from Bio-Sharia to Robo-Sharia. So that's the one interesting aspect in this, to what extent indeed AI presents something fundamentally novel as an ethical challenge. A second interesting connection I see is indeed one in which we reverse a question that we used to have before. The question used to be quis custodiet custodies, that is, the distrust we have in humans making law, making rules. And the idea of the rule of law as being something that controls human judges from discretion and binds them to some objective law. We turn this around now. We now have algorithms doing the law, and we ask, and all three speakers in fact ask for human control now of the technique. So a real interesting reversal also of the ethical question. It's no longer limiting humans to technique, it is limiting technique to humans. And that raises, I think, the third ethical issue that arises for me, especially from the Kazakhstan example, where we seem to have conflict between a very modern legislation on the one hand and a fair amount of cases that were reported in which massive data spillage has happened. It raises the third ethical question really of how much is possible in fact. So when we say we need to control the technology, one question is who is the we, and one question is to what extent can we even do what we set out to do. I just leave these as three of my impressions, and I open up for questions or comments from the plenary, and I'm sure there must be plenty. Jeff, please. We have about 15 minutes now.
Oh, that's a very brief question, but still. Many years ago, I was a legal advisor to an Italian startup that tried exactly to do the same as the girls. And therefore, I have a question to the first speaker. My advice to that startup was, and it's basically technically the same. I said, what you are doing is you conclude contracts with future judges that are, in essence, gambling contracts, and they are void. How would you react to that? So that if I would be approached as a judge and you, in fact, what you do is gambling with money, and that has nothing to do with justice.
Yeah, well, that's certainly an issue, precisely because, as I said, the question of impartiality is not put forward anymore. So the kind of problems they face is, how is it possible to make sure that these jurors don't communicate? Or, so it becomes security issues, anonymous kind of processes and so on, that are very far from the question you're asking, which is, of course, an ethical question. You know? So I don't know how they solve the problem. I just see that there is one, you know, and that's what I've been telling them actually, because they are placing tax, although its power is Argentina. It's started in Argentina. So I don't know how I can exactly answer the question, but I would, as a philosopher, I would just, you know, raise the issue.
Thank you very much to all the speakers. My question is directed, I think maybe to the first speaker, but I think the three of them, and people in the room also can react. And it relates to the role of the person that interacts with the system, let's say the juror here. In the legal world, we give the jury member instructions to guide them to know the limits, the boundaries, what is expected. In this system that we presented in the first speaker, and in other systems, how does it work? How is what are the instructions for the person that is interacting? And also, what is the limit and the control on the action of that person? Because maybe that could be the key here. Not about the tool itself, but how we use the tool. So maybe I invite for reflections on how are people instructed and guided in using the tool.
Yeah.
Thank you.
Yeah, thank you for the question. I don't know if I can answer that. What is very striking for me is the complete opacity, you know, of these instructions and the way to proceed. I paid this fee to become a juror 3 years ago. I'm still waiting to be called for a case. I'm still waiting, and I don't exactly know, you know, the mathematical process that is used in order to choose the jurors. I still don't know. You know. So I think there are opacity at all levels, and I mean we are pointing to one of them, which is how does it work? You know, which is of course something the juror should be entitled to know. But I can't answer, and if you go to the website, I don't think you will find a list of instructions. I have been there recently, but I don't think that it's so clear. That's one of the issues, of course.
Can I intervene on the topic?
Sure.
Well, I mean, I think that the question is actually very relevant also in relation to problems of Sharia compliance. In which sense? In the sense that what is sometimes not really transparent, and it becomes even less transparent for robotization, is the nature of the legal advisor. How the legal advisor has been chosen, of course, in the Islamic financial market, we have Sharia boards, so we can check the identity of the people sitting in Islamic banks as Sharia advisors. Of course, this does not undermine the issue of why these people have been chosen. So, there are lots of articles about the idea of fatwa shopping. Certain Sharia scholars are chosen because they are actually useful for promoting certain programs. Now, if the problem is already relevant, speaking of human beings acting as legal advisor, clearly the lack of transparency is even more dangerous in terms of robotization, because we do not have control on this technology. And I see more in general here an issue of democracy in terms of how people can actually be involved in what can be described as the rule of law. The rule of law is not the law itself, but it is linked to parliamentary position, to the everybody can check, so there is an accessibility to information. Now, of course, this relates to secular law, but in terms of Sharia, clearly I would not use the term democratization, but in terms of belief, in terms of how we care about the faith, and so the ethical dimension of the human beings, this lack of transparency clearly creates an additional problem when we move towards this new technology as well.
Thank you.
Can I add just one thing? Sure. Yeah. Just to go in the same direction, Valentino just mentioned the fact that there's a lack of control on these technologies. But I think that it's advertised that using algorithms would bring a perfect deterministic kind of procedure. But we have to realize that this is just impossible for mathematical reasons. There are theorems that say that there are mathematical limitations to algorithms, and this has a direct impact on security. So you can't make sure that a system is perfectly secure for mathematical reasons. So I think this is something to be aware of.
Yeah, just for be short, John.
Very brief, because we have 2 more questions. That's okay.
Yes, just a comment. I would say that there is no space at all for control. So law is also a space of interaction, and this is exactly the problem. There is no space, it's just a flow of information in time, and this creates for us, I think, a big issue.
Thank you. I'll take 2 questions together, 3 questions. First Elena, then here, and there. I ask you all to ask those questions briefly, and then everybody has a chance to listen.
Thank you. I will be brief. Congratulations to all the 3 of you. I wanted to ask or comment something to you, Professor LASSÈGUE. For example, you mentioned that about the jurors and the entry fee, and that they lose their entry fee. So it reminds me, it's not about gain and loss. It reminds me of law and economics, of course, and all the so-called faults of law and economics. You mentioned the connection with behavioral law. So there are so many books and articles written about law and economics trying to correct somehow their own insatisfaction, and so we see law and economics and irrational choices, because people do not, it's not certain that people react rationally as law and economics believe, the theory of law and economics believe. So we steadily see movements like that, correctional movements somehow. And I'm not against mathematics, of course. It was my favorite course in the high school and everything. I hope that I don't seem conservative, it's nothing like that. I'm not certain that we can, we should impose measurements to the people's behavior, especially in justice. It's a bit fluid what I said, but if you could comment something on this, I would be happy. And Dr. CATTELAN, again, it will seem a bit conservative, I hope not. I mean, religion, we know in comparative law that is in the center of the tradition. And tradition has not necessarily a bad sense. So it's the core of people's beliefs, and it's one of the most influential factors on laws, on many laws. So is it so simple to measure and change the behavior? I am not blind to the mass reaction but it's not what interests me most. What interests me is the reactions of the people in front of something not just new, but something that could be considered as offending or frustrating their own beliefs or their own way of life. I hope it was clear enough. Thank you.
Thank you, Cindy. I'll connect two more questions and I will give you all the chance to respond. Maybe first here and then.
Okay, thank you. I have maybe not legal, but in short question. Did you think about the legal personality of artificial intelligence from a philosophical perspective? What do you think about what kind of AI we will have in 10 years? So today we're talking about controlling, but when we start to talk about the responsibility of artificial intelligence. So philosophy is so important in this book because it probably should start from religion, right? And what do you think about from the religious perspective? Now people starting to believe in artificial intelligence. So maybe it's a maybe short but very comprehensive question.
And the third and last question.
Thank you for your presentations today. I am a senior student in Istanbul University and researching the existing legal regulations and aim to present a suggestion of my own in my article that I'm currently working on. So I would be honored to hear your opinions about my main question of my article. Will it be more appropriate and be more fitting into ethical rules to create a number of general principles such as pillars, 8 principle of law, or to do specific enactments for each of types of AI or each type, which is etc. Thank you so much.
Thank you. And I give each one of the three speakers a chance to respond to as much or as little as they want in as little time as they can. So we have a coffee break in the same order in which we had the presentation.
Okay, right. So I will try to be brief. First, I think it's good news that there are mathematical limitations. You know, it's good news. It means that there is a space for deliberation and discussion, and I'm sure that Valentino will say the same thing. That's something that we have really to favor. You know, we can do all of this on the contrary. Second thing about the responsibility of AI, I mean, implicitly what you say is that there is some kind of agency in AI. And, well, this is a philosophical debate. I mean, should we actually project some kind of agentivity on AI? I'm not sure of that, you know. So that's my second point. And my third point about these general principles, more situated ones. Well, I think you're right. I think it's very difficult to imagine general principles without going to the particular cases and the particular kind of technologies that you use. So, I think there must be some kind of balance. I'm not a jurist, but I would love to read your article if it's written. Right.
Thank you. And I think Dr. CATTELAN, you have the last word.
Yes, very briefly. I'm sorry I can't discuss with you later, but in terms of interaction between law, religion, normativity, it's of course a very huge field of debate. What I would say on the topic is that, of course, human beings are social actors. You can shape religion in terms of normativity, theology, you can use different labels, there is a critical school about what is religion, and to define Sharia law as a religious law has become quite outdated as well. Now, with my talk, I didn't want to say that Sharia is going to disappear. My basic purpose was to underline how much Sharia is changing in terms of its re-elaboration by Muslim believers. And this makes a link also to the final question about the need for regulation of these new entities and political personalities. Sharia scholars are working on advancing the ijtihad, the approach to critical sources. So, I mean, this is not something which is debated only by legal scholars and comparative lawyers. It's a epistemology which is invading the Muslim societies. And as legal scholars dealing with matters related to religion, I think that this kind of transdisciplinary approach, looking into mathematics as well and digital behavior, law economics, is actually what has become not the new frontier for comparative law, but what we have to do just to keep our voice useful for social actors as well.
Thank you very much. Thank you to all three speakers. Thank you to the questions from the audience. And thank you to those who will be providing us with coffee in the break. And we reconvene in 15 minutes. Thank you very much.